Hi guys, thank you so much for clicking this video. This is Battle with Ola and my name is Mujola Oluwa, and today we want to talk about summary judgments. Now, someone has asked a question about summary judgments. I want to make a video, explaining the two of them. They are similar, but they are not exactly the same. So we're going to be looking at summary judgment on the 11 of the High Courts of Lagos Civil Procedure Rules, and we're going to be looking at undefended list under Order 21 of the High Court of Abuja Civil Procedure Rules. So you can check these orders out, and I hope that this video will clarify whatever it is that needs to be clarified for people that ask the question and for everyone that wants that needs to find out about this. Please, if you need paid consultation, or if the questions that you want to ask on the channel, if the answers to those questions are things that are tailored particularly to only you or your situation, that means you need paid consultation. So you should book a session using the link in the description box, and a lawyer, namely me, would speak to you, at a scheduled time at a fee. But if you're asking a question that would benefit everyone, that other people can learn from, you can always leave the comments in the comment section or send an email to houseoflivingstones@gmail.com. If you have done one, you don't need to do the other. That is, if you have already left a comment, you do not need to send it by email. I will catch either, so there's no need to duplicate. Thank you so much. Also, I thank all the people that have been sending me positive feedback. It's important for me to know that there are people who love, enjoy, and benefit from what we do on the channel, especially people who find value in it. That's the kind of feedback that makes me really happy. Thank you guys for seeing something and saying something. So let's talk about the summary judgment first, then we'll talk about the undefended list. Summary judgment is a procedure that is used when you as a claimant believe honestly that the defendant has no defense to your claim. That is, you want to ask the court to make an order compelling the defendant to do something or to cease from doing something, and you believe that they would not have any defense to you asking the court for such thing. That is when you come by way of summary judgment. So it does not replace the normal procedure for coming to court, filing your processes, being served on the other party responding, and then both of you going to trial. But where you think that, oh, this person does not have any defense, no defense to this claim, you can come by way of summary judgment to save the court's time, and so that you can get what you want expeditiously. So how do you do that? You file your normal originating processes, and then you file alongside it an application for summary judgment. Now, what are your originating processes? You know that if you're making a monetary claim, for instance, or if you're claiming maybe it's a contractual matter now, you're claiming breach of contract, or you're claiming any other thing, you should come with your statement of claim, you should come with your particulars of claim, you should come with your witness statement on oath, you should come with a list of witnesses, and you should front load all the documents that you intend to tender in that during trial. In that case, you should come with those things. If you're in doubt about what a comprehensive list of origination processes should be in any matter, you should contact or consult the High Court Civil Procedure Rules. They would always tell you what you need to bring when you are laying a claim or when you're filing your processes. And of course, when you get to the registry, if your processes are not complete, the registrars will not accept it for filing. So they would guide you on what is missing and what you need to do. These things are not that difficult. So be at rest, you will always find guidance every step of the way. So once you've filed your process, you are to file alongside it an affidavit, an application now, an application for summary judgment, asking the court to deliver summary judgment on the matter. And then you file alongside that application. You remember the applications come tripartite most times. They come with an affidavit in support and a written address. Those three things, the three musketeers. I've mentioned that on the channel before. So when you're filing your originating processes and you intend to apply for summary judgment, you file your application for summary judgment, and then you file the affidavit, and then you file your affidavit in support, where you set out facts that have convinced you that the defendant cannot defend the claim that you have brought to court. And then you file your written address in support. Written address is about you citing law, making legal arguments, while affidavit is you stating facts that, oh, he has agreed to do this, he agreed to do this, he didn't do it, he was supposed to do this, he did not do it, this and that. Facts, statement of facts, settled facts. That's in your affidavit to show the court that this person cannot defend this claim. So let's not waste time going to trial and waiting for them to file a defense and all of that. Let the court just consider my claims and make a judgment on it. So that is how to come to apply for summary judgment. So after you have filed this, the application has to be motion on notice. It will be served on the defendant. So if they have a defense in good faith, they would also come to court and file their defense and file alongside it a counter affidavit to your own affidavit. Remember, response to affidavit is always counter affidavit. So they would file their counter affidavit, trying to prove to the court that it's not true that they cannot defend, they can actually defend. They actually have a defense to your matter, and so the matter should not go by way of summary judgment or should be set down for proper hearing. So that's what the affidavit will contain, and of course their own written address filed alongside. So they would file their own statement of defense and all the other documents that accompany the statement of defense, ordinarily, and then file the counter affidavit responding to your own affidavit in support of your application for summary judgment, and then a written address. So summary judgment, the procedure in Lagos and in some other states in Nigeria, found in Order 11 of their High Court Civil Procedure Rules, can be used for any type of claim. So it is not limited. It can be used for any type of claim wherein you believe that the defendant does not have any good defense or will not likely defend the matter. So when your processes are filed, they are served on the other party. So if they do not have any defense, they will not even bother coming to court. And then the court can make a ruling on your application. But if they have a defense, they would file their own defense, and then the witness statement on oath, all the works, and then a counter affidavit to your own affidavit and your application. So after filing that, they have to file this within 42 days, which is the response time for any defense in a civil matter in Lagos State. If ordinarily when you file a statement of claim and there's need for the respondent to respond so that you can go to trial, they have 42 days after you filed your writ of summons, your originating processes, to respond, and after they've been served to respond. So if the court is convinced that there's a defense and that the defendant has a case, the court will make an order granting the defendant leave to defend the matter, and then the matter will be set down for hearing and adjourned for hearing. But if the court is convinced that the defendant does not have a defense according to what the claimant has filed, after the defendant might have responded and filed their own processes, if the court is convinced that they have a case and they have a defense to the claim, the court will make an order granting them leave to defend, and then the matter will be moved into the general cost list. And then a date will be fixed for hearing. But if the court is convinced that the defendant has no defense in the matter, the court will enter judgment for the claimant, and that judgment is on the merits of the case. So it cannot be set aside except in some cases, which we're going to see much later, but it is a normal judgment. So it proceeds like a normal judgment, in that if the defendant now comes later and seeks to annul that judgment or invalidate the judgment, the defendant has to appeal the judgment, not come back to that court asking it to set it aside, but appeal to a higher court, to quash that judgment. So it is a judgment on its merits and cannot be set aside, except in 3 instances that I'm going to be mentioning after we've talked about the undefended list in Abuja. So this is what summary judgment is. Someone asked a question, how do you move an application for summary judgment? You move it like any other motion in court. Once you've filed, the defendant has been served, and you've been given a day to come and move your application. You tell the court you have an application before it. It's an application for summary judgment, and then it is supported by You remember, you can always read your the prayers you're asking from the court, the prayers before the court. You can always read it from the face of the motion paper. Lord, we're asking from this honorable court an order to do so and so and so, and for such further and other orders as the court may deem fit to make in the circumstances. My Lord, our application is supported by a 10 paragraph affidavit deposed to by a so person and a written address. We're relying on paragraph so and so for affidavit and the written address and asking the court to grant our prayers. So you move your application like that. Then the court, if the defendant has responded at that time, the court will hear the counter affidavit being moved as well and then adjourn for ruling. But if not, then the court can make a ruling or adjourn for ruling on your own application alone. So the ruling would either be that, okay, we're convinced that the defendant does not have any defense and we are entering judgment in your favor, or okay, the defender from the totality of the application and the counter affidavit moved, we believe that the defendant has a defense, so we're making an order for this case to be entered into the general cause list, and then for the defendant to defend this matter. We're granting him an order to defend. So this is how summary judgment works in Lagos and in all other states where summary judgment applies. So check the rules of court, the High Court Civil Procedure rules, for you to find out if in your state there's provision for summary judgment or not. Let's talk about the undefended list in Abuja. That's Order 21. High Court Civil Procedure Rules, Abuja. High Court of Abuja Civil Procedure Rules. So Order 21. This applies to liquidated monetary sums. That would mean that we said that summary judgment applies to all types of claims. The undefended list procedure in Abuja only applies to monetary sums, and it must be an ascertainable amount of money. So you must have calculated the sum. Say you're claiming 1 million naira now, you're claiming 2 million naira. So it must not be, a vague or a figure at large. So it only applies to monetary sums, liquidated money demands. It's laid down in Order 21, but essentially you're filing your writ of summons, your liquidating processes, and then you will file your affidavit of fact, setting out what the process is, what you're asking for, and why. So in your affidavit of fact, you must state that it is for a liquidated sum, or that it is for a debt sum, liquidated money demand. You must state that the defense has no defense, to the claim, and then you ask the court to place it on the undefended list. So it should not be placed in the general cause list. When it's been assigned for hearing, it should be placed in the undefended list, and that is where the undefended list procedure comes from. Undefended list simply means undefended cause list. So it's a separate cause list from the general cause list to show that, general cause list will usually show that these are matters wherein both parties are coming, or all parties are, if there are more than two, are coming to court to answer each of their own cases and to defend themselves. But here it's undefended, so you are the only party that's going to be answering anything before the court or making a case before the court. So it's undefended list. So you're making an application alongside your writ of summons in Abuja or any other state where it applies, asking the court to place it on the undefended list. So if the court is convinced that the defendant indeed has no defense, the court will place it will make an order placing it on the undefended list and then adjourn it for hearing. That is what happens once you make an application for the matter to be placed on the undefended list. Of course, the processes would also be served on the defendant, just like in summary judgment in Lagos. So if the defendant intends to defend, he must file an intention to defend within 5 days of the hearing date. So you must file within that period. We said 42 days in Lagos. So in Abuja, it's within 5 days. The defendant must file an intention to defend the claim. On the hearing date, if the court is convinced that the defendant indeed has a defense, the court will then move the matter from the undefended list back to the general cause list and set a date for trial, or command parties to exchange pleadings so that the matter can go on to trial. If there's no defense, the court will hear the matter as undefended and enter judgment for the claimant so long he or she is able to establish their claim in that matter. So this judgment is also on its merit. It's different from default judgment, which we're going to look at in another video, and it cannot be set aside by that same court, except there's proof that one, there was fraud, that is, the claimant, fraudulently, convinced the court that it's undefended. Two, if there's no proof of service. Service is very fundamental. There's a whole video on service of court processes in Nigeria on this channel. So if the court is convinced that there's no proof of service, on the claimant, now if it comes out that there was really no service, maybe they fraudulently put a fake proof of service, or anything went wrong, if the court discovers later that there was no proof of service, so which means that on the defendant, which means that the defendant did not even know that this matter was before the court, the court will set aside the judgment. And then if it turns out that the court had no jurisdiction to hear the matter. So these three instances are very unlikely, but they are exceptions to the rule of setting aside a judgment that comes by way of summary judgment or undefended list. So the normal way, or the only permitted lawful way of setting aside this kind of judgment or quashing it, is by appealing, because it is a judgment on its merit. It is not default judgment. So it can only be set aside by a higher court, except in the three instances where the same court can set it aside. So this is the undefended list, and this is summary judgment. I hope it answers all your questions. If you have any further questions or opinion, please leave it in the comment section, and I will see you in my very next video. Don't forget to subscribe to this.